I request everyone to keep your mobile phones on the silent mode and do not use it during the session.
No,
Kindly rise. Cooperative federalism is a system of governance where the center and state works together to iron out the differences to achieve the common goal of development. Introduction of goods and service tax GST in India was a classical example of cooperative federalism as told by former Chief Justice D.Y. Chandrachud. A very good morning to everyone. I am Tabassum, first year LLM student. On behalf of Kelly Law College, Bengaluru, I extend a cordial and respectful welcome to all on the two-day international conference on GST framework. Transferring fiscal federalism in India is being organized on 17th and 18th of April. The conference aims to encourage interdisciplinary dialogue on constitutional, administrative, dynamics on fiscal federalism. To invoke this auspicious beginning, I now invite Ms. Sahitya Pujari, student of BA LLB, to render the invocation of song.
गणनायकाय गणदैवताय गणाध्यक्षाय धीमहि गुणशरीराय गुणमण्डिताय गुणेशानाय धीमहि गुणातीताय गुणाधीशाय गुणप्रविष्टाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीगणताय धीमहि गजेशानाय बालचन्द्राय श्रीगणेशाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय बालचन्द्राय श्रीगणेशाय धीमहि गानचतुराय गानप्राणाय गानान्तरात्मने गानोत्सुकाय गानमत्ताय गानोत्सुकमनसे गुरुपूजिताय गुरुदैवताय गुरुकुलस्थायिने गुरुविक्रमाय गुह्यप्रवराय गुरवे गुणगुरवे गुरुदैत्यकलक्षेत्रे गुरुधर्मसदाराध्याय गुरुपुत्रपरित्रात्रे गुरुपाखण्डखण्डकाय गीतसाराय गीततत्त्वाय गीतगोत्राय धीमहि गूढगुल्पाय गन्धमत्ताय गोजयप्रदाय धीमहि गुणातीताय गुणाधीशाय गुणप्रविष्टाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय बालचन्द्राय श्रीगणेशाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय बालचन्द्राय श्रीगणेशाय धीमहि धन्यवादः।
Thank you, Sahitya. Now I request Dr. Manoj Kumar V. Hiranat, IQAC Coordinator, Assistant Professor of Law, to deliver the welcome address and introduce the dignitaries. Sir, please.
Good morning, all. Respected dignitaries on and off the desk, and my dear students and participants. Today, we have assembled here to witness the inauguration of the 10th edition of Constitutional Law Conference organized by KD Law College, Bengaluru. This year, the theme is focusing on goods and services tax framework, transforming fiscal federalism in India. To inaugurate the conference, today we have with us Honorable Mr. Justice S. Rajan. I take this opportunity to introduce His Lordship, Honorable Mr. Justice Rai Raja PC obtained his LLB from the University of Colombo and his LLM from Trinity College, London, United Kingdom. He was also enrolled as a barrister and solicitor and went on to serve as a judge in the Republic of Fiji. He was called to bar in the year 1988 and joined the Attorney General's Department in the year 1989 as a state counsel. Over the years, he rose through the ranks to position of Additional Solicitor General before being elevated to the judiciary. During his tenure at the Attorney General's Department, he prosecuted numerous high-profile criminal cases, including white-collar crimes, and headed several special prosecutorial units. In the year 2016, he was the first Indian origin throughout the proud history of the Sri Lanka legal system to be conferred silk by His Excellency, the President of Sri Lanka. And in the same year was appointed a judge of the Court of Appeal. Then in the year 2019, he was elevated to Supreme Court of Sri Lanka, where he served as the senior most justice, having delivered over 300 judgments, including several landmark decisions throughout his judicial career. Beyond the bench, Justice Surai Raja has made a significant contribution to legal education and scholarship. He is a member of the Incorporated Council of Legal Education Sri Lanka and serves as a lecturer and examiner for postgraduate and doctoral programs at the University of Colombo. He has published research articles in numerous domestic and international journals on law and social sciences, and also conducts training program for judicial officers at the Sri Lanka Judges Institute. In the year 2024, His Lordship had a distinct honor of being invited as a guest of honor to the Commonwealth Attorneys and Solicitor General conferences held in New Delhi by the Government of India through the Attorney General of India. He is a patron of the Commonwealth Legal Education Association, which promotes and fosters high standard of legal education across the Commonwealth. He is a commissioner of the Judicial Services Commission of Sri Lanka. Recently, he was appointed as acting Chief Justice of Sri Lanka. He was a senior most judge of the Supreme Court. Since the inception of the Superior Court of Sri Lanka in 1802, he is the first Indian origin to be appointed both as a judge of the Court of Appeal and the Supreme Court. With this brief introduction, I extend a warm welcome to Honorable Justice Surai Raja, sir. Welcome you, sir. May I request now Dr. Mahesh R.S., coordinator of the present conference, to present a sapling to His Lordship and extend a warm welcome. Thank you, sir. And today we have with us Professor Dr. V. Vijay Kumar to deliver the keynote address on the occasion. I take this opportunity to introduce briefly Professor Vijay Kumar. Professor Dr. Vijay Kumar is a distinguished academician with more than 4.5 decades of experience in legal education. Sir began his academic journey as an assistant professor at the Presidency College, Madras in the year 1978 and joined National Law School of India University, Bengaluru as its founding faculty and as a senior assistant professor of law in the year 1988. Went on to become associate professor in the year 1992 and professor of law in 1997. Sir administered the United Nations High Commissioner for Refugees chair on refugee law between 1997 to 2018. He was the chairman of the Undergraduate and Postgraduate Council and also Register of NLSIU Bengaluru between 2005 to 2008. Sir was a Vice Chancellor of the Tamil Nadu Dr. Ambedkar Law University, Chennai between 2010 to 2013 and the National Law Institute University, Bhopal from 2018 to 2023. He was a member of a Karnataka State Higher Education Council, Bengaluru between 2011 to 2016. He was a visiting professor at University of Passau, Germany, and visiting scholar at York University, Toronto, Canada. He was an exchange visitor at the National University of Singapore. He was a member of the Board of Governors of the Asian Law Institute at Singapore National University, representing the National Law School of India University between 2003 to 2010. and also designated as Deputy Chairperson of ASLI in the year 2009. Sir has served in a different capacities in several statutory bodies of a different state and private universities and autonomous institutions across the country. Sir has published more than 50 publications in national and international journals and also chapters in the books. He was one among the 6 experts at the Michigan Colloquium in the development of Michigan guidelines on internal protection alternative organized by Professor James C. Hathaway at the University of Michigan Law School, USA in the year 1999. He was one among the 3 project leaders to study impact of armed conflict on children in East Asia and the specific region jointly with UNICEF and the Center for Refugee Studies, York University, Toronto during 2002 to 2004. Sir has received several awards from the different forums and institutions. To name few, the Indian Red Cross Society presented the Best Vice Chancellor Award in the year 2011, and at the 63rd anniversary of the Geneva Conventions Day in 2012. He was awarded the Vijay Gupta Award for services in the field of law at the 27th V.K. Sinha Foundation ceremony in Bhopal in the year 2022. He was privileged to find honorary mention in the Forbes Legal Power List 2022. He received the Overseas Friend of India Award for his services in the field of law in India at the House of Lords on 25th May 2022. With this brief introduction, I extend a warm welcome to Professor V. Vijay Kumar sir. And now may I request Dr. Vishnu Prasad, Associate Professor, to present sapling to Professor Vijay Kumar sir and extend a warm welcome. Thank you, sir. I also extend a warm welcome to President of the program, Dr. J. Mallikarjuna, Principal of Kelly Law College and Dean Faculty. Welcome you, sir. Now, may I request Ms. Nadelda Rasok to present sapling to Principal, sir, and extend a warm welcome. Thank you, Nadelda. I extend warm welcome to the resource persons of the plenary sessions who are present here in the gathering, and extend a warm welcome to all the faculty members and the participants from other institutions and my dear students to this 2-day international conference. Welcome you one and all. Thank you.
Thank you, sir. May I request the dignitaries on the dais and also Dr. Mahesh Aryas, Conference Coordinator and IQAC Coordinator Dr. Manoj Kumar V. Hiremat for ceremonial lighting of the lamps, followed by the release of Compendium of Abstracts. Thank you, everyone. Now we will release the Compendium of Abstract. Thank you, everyone. It is indeed an honor to invite today's chief guest, Honorable Mr. Justice Turai Raja, former Judge, Supreme Court of Sri Lanka, to deliver the inaugural address. Sir, please.
Namaskara, Vanakkam. Respected President and my dear Professor, there is some secret which I can share with you. When I registered for my PhD at National Law School, he was my professor. So therefore, still he is my teacher. That's with the love and blessings that I have him on the board. Distinguished members of the faculty of the KLE Law College, learned members of the bar, esteemed scholars, policymakers, administrators, and my dear students, ladies and gentlemen. It is a privilege to be with you in this morning at KLE Law College, an institution whose 50 years journey in legal education is itself a reminder that serious nations are built not only parliament and courts, but also in classroom, libraries, and conversations such as this. I thank the organizers most warmly for inviting me to deliver the inaugural address on the conference devoted of GST and fiscal federalism. At first glance, that may sound like a subject reserved for specialists, spreadsheets, and very patient taxpayers. But the truth is much larger. Taxation is one of the clearest mirrors that of state. It reveals how a constitution distributes power, how institutions treat one another, and how government finally meets the ordinary citizen. One does not usually expect tax conference to become genuinely interesting even before or after breakfast. Yet, tax has a way becoming unexpectedly dramatic. A single word can alter commercial behavior, unsettle a state's revenue expectation. In fact, I have a personal experience on this. I delivered a judgment interpreting a word, the notice, which overruled 54 years of judgments in Sri Lanka, and the revenue to the government loss is 8.2 billion rupees. That's an interpretation of a word. Or the state revenue expectations, or send lawyers in search of meanings no dictionary had in mind. That is why tax law never merely about arithmetic. It is public power written in numbers. Yet the theme before us is too important to be left to specialists alone. Before I start the core matter, I'll just give you two incidents, and just for you to think whether there is relevance or not, we'll think about it later. One is the Kautilya in his Arthashastra, he defines how to collect tax. He says there's a collection of tax. How to collect tax is, it's like bee collecting honey from the flower. You know, the bee goes, collects honey from the flower. Does it do harm to the flower? It's not. It is. It takes the honey out of it. Does it good to the flowers? It is, because it takes the pollen to another flower. But does it crush the flower? Does it kill the flower? I don't know. That you have to leave it. That's one type of thing. Similarly, I'll give you another incident. How many of you all take tea, drink tea? Okay, almost everyone. Very good. Because I come from the best tea producers in the world. Right? And mind it, that is only by the Indian origins who did that. And none can do that in the world. Right? I'm take proud of it. proud and pride out of it. You know how the teas are plucked. I don't know, you may not know. They just pluck the tea, that the nip, they nip it at the bud, the first four leaf. And that's not in India. I'm sorry. It's only in Sri Lanka that pattern is followed still, even for more than 227 years, that the tea plucking it's an art. It's a science. You pluck it, then you dry it, you crush it, then you blend your tea. So to get a tea, you kill a plant. Do you get or not? You get it, right? So leave these things out. There's one side says collect honey, and the other side is have a best tea. Okay, let us get to the subject matter. Whether it is relevant or not, we'll see it at later. If Professor gives me a little bit time of his time, I will explain how it's relevant to you. The conference brochure rightly presents the subject as one that calls together judges, lawyers, economists, political scientists, policymakers, public administrators, practitioners, researchers, and students. That is entirely correct, for goods and services tax is not only merely tax reform, it is a constitutional event. It is not only a matter of revenue design, it is also a matter of federal trust. It is not simply about compliance architecture. It is about how the power is shared, how burdens are justified, how institutions listen to one another, and how citizens experience the state in everyday life. I have to give a small addendum here. In the morning, we had a small chat in our waiting room. Mr. Kodandaraman gave me a book. I had a glance within 2 minutes. And what I wrote here, he has summarized in his book and he has explained in the books. So therefore, please mind it, I didn't borrow it from there. I thought it differently, but he thought it differently. I thought, okay, my speech is on the correct path because he had done a good research and did a very worthy writing. I think he should donate a book to the library for you all. I'm borrowing and getting a book for you. For the students to research. That to my mind, the first proposition and which I wish to begin. A GST system must be judged not only by how much it collects, it must also be judged how it collects, how it distributes, how it coordinates, and how it explains itself, and whether in the end it leaves the taxpayer with a sense of that the law is firm but fair. A state may raise impressive revenue and yet quietly exhaust public confidence. And once confidence is exhausted, even the most sophisticated fiscal machinery begins to work against itself. This is especially true in a federation. The federalism is not merely an arrangement for distribution functions between one capital to several regions. It is a constitutional method for managing diversity without dissolving unity. It is the art of allowing differential political communities to belong to one republic without feeling reduced to administrative branch of a single will. And therefore, fiscal federalism is not a technical annex to the Constitution. It is one of the ways in which Constitution teaches its institution how to live with one another. The introduction of GST in India represented a bold and historic restructuring of that relationship. Through the Constitution, 101st Amendment, I guess, Act number 2016, India created a new constitutional architecture for indirect taxation, including insertion of Articles 246A, 269A, and 279A, and with them a new logic of shared fiscal authority and intergovernmental coordination. That reform deserves admiration for its scale, ambition, and institutional imagination. Few democracies undertake such wide structural changes without prolonged paralysis. India did so through constitutional design, political bargain, administrative effort, and public expectation on a remarkable scale. but precisely because GST was so significant, it also raised foundational questions. When taxpayers are pooled, tax powers are pooled, how is autonomy preserved? When uniformity is pursued, how is diversity respected? When institutions are designed for cooperation, how do we prevent cooperation from hardening into quiet centralization? When the promise is simplification, how do we ensure that complexity does not merely migrate from statute books to digital portals? If anyone who has dealt with modern tax portal knows that simplification can sometimes be an aspirational concept. One upholds a document with complete confidence. The portal responds with quiet superiority of a school examiner, announces that something is invalid, and declines to say exactly what. After a few rounds, even a patient citizen begins to feel that the machine developed views of its own. Technology is indispensable, of course, but even technology must learn manners. My second proposition, therefore, is this. The great question in fiscal federalism is not whether there will be a friction. There will always be a friction. The real question is whether the constitutional design converts friction into dialogue or into resentment. A federation does not fail because of its units disagree. On the contrary, disagreement is normal. What matters is whether the system preserves the dignity of disagreement. Do states feel heard or merely informed? Do institutions deliberate or merely ratify? Are financial arrangements experience a partnership or as a dependency? These are not sentimental questions. They go to the very heart of the constitutional endurance. I may pause a little. You know, there is a matter before the parliament these days, and it's argued. And you know that it says South had been ignored and the North had been more focused. And you can see the arguments put for and against this issue before the parliament and before the council. In this context, one of the most consequential features of the Indian GST model is the Goods and Services Tax Council. The council is a constitutionally created forum in which the union and the states meet, reason, recommend, and negotiate. It is, if I may put it in this way, the constitutional roundtable of India's indirect tax federalism. It is very extensive. Its very existence recognizes a mature constitutional truth that in a vast and varied federation, fiscal coherence cannot be sustained by command alone. It must be cultivated through structured conversation. This is why Supreme Court of India's decision on Union of India Mohit versus Mohit Mineral Privates Limited. In such enduring significance, the judgment did not weaken cooperative federalism. It refined it. It reminded us the constitutional cooperation is not the same as constitutional subordination. The court recognized the centrality of the GST Council, but also made it clear that its recommendations do not operate as if they were binding decrees upon sovereign legislatures. That was not a blow to the federal project. It was a defense of its constitutional integrity. A council is strongest when it persuades, not when it replaces the constitutional autonomy of those who sit within it. That insight is larger than the GST. It speaks to all federations. In every federation, there is a permanent temptation to confuse efficiency with centralization. Uniformity is attractive. It reduces transaction costs, produces cleaner narrative, and it's often easier to administer. But constitutional life is not measured only in the efficiency. The point of a federation is not to create the most geometrically tidy map of power. The point is to produce a just, workable, and legitimate order in a plural society. Every federation learns sooner or later that agreement cannot be commanded into existence. It has to be worked at. Money tends to test relationship very quickly. Even the most affectionate households, the conversation becomes remarkably precise. When the question is who pays, who decides, and who carries the deficit. Federations are not very different. Fiscal trust survives not because disagreement disappears, but because both sides remain persuaded that the process is fair. The framers and the reformers of modern constitutions understand something else as well. Tax is never only about money, it is about moral authority. In one of my own judgments in a tax matter, I refer to the wisdom of the Arthashastra, which advises the revenue should be collected as the bee gathers honey from the flower, gently without harming the blossom. It is magnificent image because it contains both restraint and intelligence. The state must collect, a government cannot run in poetry, press conferences, and good intentions. Road must be built. Judges must be paid, hospital staff, schools sustained, and public order maintained. Revenue is indispensable. But the ancient text also teaches that method matters. The bee does not destroy the flower or order to prove its efficiency. It draws sustenance while preserving the source of life. I sometimes fear that the modern times that image is in danger of being replaced. Taxation must become the plucking of tea leaves by rough hands, stripping branches after branch, and impatience to maximize extraction. That may produce a basket of leaves for the day, but not a healthy field for the session. A wise tax system gathers without humiliating, enforces without theatrically, and compels without forgetting that the taxpayer is not an adversary of the state, but one of its authors. That in my mind is where a discussion on GST deepen. Too often our debates fall into a narrow pattern. One side speaks a language of revenue, buoyancy, efficiency, and market integration. The other speaks the language of state autonomy, compensation, institutional imbalance. Both are important, but neither is sufficient by itself. The deeper question is whether the GST can evolve a model constitutional taxation that combines four things at once: productivity, legitimacy, federal trust, and taxpayers' dignity. If it cannot do all four, it will remain incomplete. Let us look briefly at the world beyond India. Not because comparative law provides ready-made answers, but because it sharpens our imaginations. Canada offers one model of fiscal pragmatism. It has federal GST, but provincial participation takes different forms. Some provinces operate within a harmonized regime, while others retain separate provincial sales tax or distinct arrangements. The lesson there is not that diversity is superior to uniformity. The lesson is that federal systems sometimes preserve stability by allowing asymmetry rather than denying it. Australia offers another model. The federal government collects GST, but the revenue pool is distributed to the state and the territories with horizontal fiscal equalization playing an important role. That model places a great emphasis on distributional fairness across jurisdiction with different fiscal capacity. It reminds us federal solidarity is not achieved simply by collecting together. It must be reflected on how resources are shared. The European Union, though not a federation in the classical constitutional sense, presents fascinating illustration of another reality. In a highly integrated market, VAT system increasingly move toward digital reporting, e-invoicing, and coordinated compliance framework. The recently adopted VAT in a digital age reforms signal how profoundly tax administration is being reshaped by technology. And the OECD's recent work on digital continuous transactional reporting reflects a broader global trend toward real-time or near real-time tax information system. Yet here too, a warning is necessary. A digitally advanced tax system is not automatically a just tax system. Technology can reduce evasion, improve visibility, and lower certain transaction costs. But technology can also centralize discretion, amplify opacity, and create new asymmetries between powerful administration and bewildered citizen. When a tax system becomes highly digital, questions of data protection, procedural fairness, system accessibility, cybersecurity, and grievance address cease to be side issues. They become constitutional issue. In the future, some of the most important debates may not concern rates at all. They may concern algorithm, reporting burdens, system outages, interoperability, data retention, and automated enforcement. We may discover that old contest between the citizen and a tax collector has now disappeared. It is simply acquired a dashboard. And this brings me to the third proposition. The future of fiscal federalism will belong to those jurisdictions that understand that revenue administration is not only an exercise of control, it is an exercise in truth design, in trust design. The citizen complies more readily when the law is intelligible. The process is proportionate, and the institutional voice of state is calm rather than predatory. The business community responds better to certainty than surprise. States cooperate more constructively when consultation is real, and the court draws into fewer conflicts when statutes, delegated legislations, and administrative action remember that legality is not a procedural inconvenience. It is a foundation, enforceability itself. Sorry, I know it's a little boring, but unfortunately I have to put the house in order. That's what I'm giving the theme to you. This is why judicial review remains central even in tax matters. We sometimes hear it said that should be cautious in fiscal questions because taxation belongs to the policy domain. That is true up to a point. Courts do not draft budgets, design economy models, or choose revenue targets. But taxation is not a constitutional free zone. Taxing statutes remain statutes. Delegates instruments remain instruments of law. Administrative action remains subject to legality, rationality, fairness, constitutional structure. The power of tax is great, but it is not sacred in the sense of beyond review. In a constitutional democracy, no public power is. I say this not to invite more litigation. No judge after a full day in court secretly hopes to spend the evening with another bundle of tax papers. Courts do not looking fiscal quarrels, but neither can they look away from the constitutional implications fiscal designs when tax changes the balance of power within Federation Code and must be careful. When compliance burdens threaten fairness, court must ask difficult questions. And when executive convenience begins outrun constitutional discipline, judicial restraint cannot mean judicial indifference. At the same time, courts alone cannot resolve the challenges of fiscal federalism. Indeed, healthiest federations do not depend excessively on courts to repair every political disagreements. They build political habits capable preventing legal breakdown, litigation, constitutional safety, and for statesmanship. This is why the conference of this nature matters. The last question matters profoundly. The society tax system expresses what is believed about obligation, reciprocity, public goods, and fairness. Tax can be framed as a burden alone, and if it is, resistance becomes natural companion, or it can be framed as a civic contribution to a shared constitutional project, in which case compliance is supported not only by penalties, but by legitimacy. Of course, no population is cheerfully files returns out of philosophical enthusiasm. Let us not romanticize. I have yet to meet a citizen who wakes up in April whispering, "What a glorious morning for indirect compliance." But citizens are more willing to bear legal burdens when they believe the system is principled and proportionate and purposeful. That is the message I hope this conference will advance. To the students present here, let me say a special word. You are entering law at a time when the boundaries between constitutional, tax law, technology, political economy, and public administrations are rapidly dissolving. Do not allow yourselves to be trained into intellectual compartments too early. The finest public lawyer of the future will be those who can read constitutional text, understand institutional design, recognized an economic incentive, question a technological system, and still remember the human being at the receiving end of the law. If you can do that, you will not merely practice law. You will help preserve democracy, constitutional democracy in an age of administrative acceleration. To the scholars scholars and the practitioners, I say this with respect. Conference matters when they generate more than paper. Conferences matter when they generate more than a paper. They matter when they refine language, unsettle assumptions. They produce framework and institutions can actually use. I hope the deliberations over these 2 days will do exactly that. The subject before you deserves rigor, candor, and imagination in equal measures. Let me close where I begin, with the nature of taxation itself. The question is whether the state should tax. It must. The question is whether the federation should coordinate. It must. The question is not whether technology should support compliance. It should. The real question is whether these things can be achieved in a manner consistent with the constitutional dignity. Can the state collect tax without overreaching? Can the union lead without overshadowing? Can the states participate without feeling diminished? Can technology assist without dehumanizing? Can law enforce without losing wisdom? If India continues to ask those questions seriously, and if institutions continue to answer them with constitutional maturity, then GST will come to be seen not merely as a tax reform of immense scale, but as evolving constitutional experiment in how a great democracy learns to share power, pool resources, and preserve trust. And that ultimately is larger message I wish to leave with this distinguished gathering. A successful tax system is not one that merely enters the ledger. It is that enters the constitutional conscience of a nation. It is one that enables development without eroding dignity. It is one that raises revenue without impoverishing federal trust. It is one that understands that the money may sustain a state, but legitimacy sustains a republic. If the B of the Arthashastra still has something to teach us, it is in this wisdom taxation lies, not only gathering nectar, but in preserving the garden. It is with that hope that I have the honor to inaugurate this conference and wish its deliberations every success. Thank you.
Address. Sir, please.
Professor Mallikarjunaya, the presiding officer of this inaugural session. Mr. Justice Raja, former Judge of Supreme Court of Sri Lanka. Mr. Kodan Raman, my learned colleagues at KLE and other educational institutions, my dear students, invitees, ladies and gentlemen, very good morning to everyone present here. It is indeed a pleasure to be part of this inaugural session because 16 years ago, even before the GST was formalized, we organized the national conference at the National Law School of India University. And it was presided over by the then retired Chief Justice, Justice Rajendra Prasad. And we invited experts from Canada and a few other countries to come and share their expertise in the formulation of GST process. And ultimately it became part of that history in 2016 when the GST was rolled down. It is interesting for the students to note that the GST was first introduced in France in 1954. And it was introduced in a state which is unitary in nature. So it is much more easier for them to roll it down because there is no states to demand autonomy. There is no political party, organization, or whatever it is to demand for regional autonomy in whatever form. So it was much more easier for France to establish the system. Today, GST in different forms may be working in about 160 plus countries. So India is one among the latest additions to the list. It is just 10 years, what it has done and what it has not. I would like to place certain observations which are not tax specific, but it is constitutional law specific and more specifically federation specific. The concept of federalism is not fixed one. If some of your teachers or some of the books and the articles that you read tell you that federalism is only fixed one, please don't trust them. Federalism is an evolving feature, and so is taxation. when you bring both of them together, it continues to evolve in all dynamics. Therefore, in India, if somebody, because it took 43 years for the Supreme Court to say that we have a federal constitution, and then it's a basic structure. Though Dr. Ambedkar mentioned on 26th November that India is a federation, the states are sovereign in their own jurisdictions, but still the court took some time, but that's part of the game. I don't want to blame the court for this, but I'm only trying to drive home this point. Federation, the concept of federalism is an evolving one. Every day, every year that you pass by, possibly there are certain changes brought to what you see in law and what you see in politics. If this being the case, you can understand how the federal model in the US has evolved over a period of time. Lucky because all the 50 states have their own constitutions. But in India, we have a single constitution, both for the federation, for the union and the states. It has certain advantages and it also has certain disadvantages. I am not going to speak much about it. But I can only tell you that no two federations are identical or the same. Right? Every federation is distinct in some form or in some feature or the other. And therefore, if somebody says India is not a federation, it is a quasi-federation, compared to strict federation, there is nothing called a strict or loose federation. So therefore, please keep this in mind. No two federations are similar or identical. And therefore, the second proposition that I mentioned is that it is an evolving concept. Dr. I.O.D. Dukashek, who published a book on comparative federalism way back in 1970, has beautifully analyzed this concept of federation. And then I would like to quote him because it is arising out of a conference on federalism, which he comprised and published this book. According to him, I quote, "There is no accepted theory of federalism, nor is there an agreement as to what federalism is exactly. The term itself is unclear and also controversial. It is often used to describe a process of combining territorial communities that previously had not been directly joined into a new unit of common interest, policy, and action, or the opposite process of decentralization of power. In addition, federalism is also a term used to describe the result or the tools of federalizing process, a constitutional federal system and its institutions." Although this observation of Dukashek was made exactly 56 years ago, right, published in 1970, the situation has not changed much. Diverse definitions on the meaning and nature of federalism continue to occupy our discourse every day in the law schools. And the concept of federalism is perhaps more elastic concept, changing according to time and other dynamic forces in economic, social, political conditions in a state. However, the basic concept remains the same. So we understand what is meant by federation. Okay, there are two levels of government, one central on, the state level government, maybe the local self-government, if at all we accept them, right, and nothing more. Therefore, my dear young friends, today federalism world over is undergoing greater changes because of the imposing concept of globalization. And if we don't understand this process or the impact of globalization on federal structure world over, including India, I don't think you will understand and appreciate the concept of federalism in the first place and the concept of unified taxation in the other place, right? With this process of globalization taking roots and impacting all the countries in one form or the other, it has left immense impact on federal structures than ever before. This impact of globalization on federal constitutions has been rightly observed by Daniel J. Leza. According to him, I once again quote, globalization has been most marked in the economic sphere, allowing the development of arrangements of a political and social as well as an economic character that increasingly requires some kind of constitutionalization. The world today is filled with discussions of globalization, especially in the three spheres deemed to count most for human progress: economics, human rights, and communications. Progressive voices of various shades of opinion are discussing ways in which this globalization can be advanced so as to increase the opportunities for human happiness, while conservative voices are bewailing globalization as robbing the world's states of their political sovereignty and the world's people of their cultural heritage for what is perceived as no more than a mess of pottage, or one likely to turn sour at that. So this impact of globalization on every federal structure, not necessarily only federal structure, because it equally impacts the unitary states as well, or even the kingdoms world over. Once again, Dukashek made a mention, I will skip that. But in 2002, the then president of this country, Dr. Abdul Kalam, while assuming his office as the president of India on July 25th, 2002, had observed, I quote, India is a union of states based on the framework of cooperative federalism. Right? So now we are adding something prefix, right? Federalism to cooperative federalism. And today we are also talking about competitive federalism. And some of the judges in the Supreme Court, just like Justice Ahmadi, called it as pragmatic federalism. So they are giving titles to federalism to identify the way that they could express their feelings towards this union of states. There is also the requirement to develop competitive strengths for the states. See how beautiful the president had put the competitive strength of the states so that they can excel not only at the national level, but also at the global level. So he was trying to elevate the status of the states to play beyond the borders of India, right? And to that extent, competitive spirit must be there in the states. This competitiveness, according to him, helps in ensuring economic and managerial efficiency and to be creative to meet new challenges. These are essential to survive and prosper in a fast-changing world of today. In addition, in order to strengthen democratic processes and institutions, we should all truly strive for substantive decentralization. I think the then President, late Abdul Kalam, very beautifully put the union in perspective, the role of the states in perspective, and what the states should also do in terms of decentralization, also put in perspective, because the 73rd and the 74th amendments to the Constitution, I think by and large remain in the Constitution and not practiced properly and effectively or meaningfully by the states. And therefore, federalism is a tug of war, not only between the union and the states, but it is also a tug of war between the state and the local self-governments, whether it is rural or municipalities. Now, this process of globalization, as we all know, involves a lot of economic, social, political, and other support systems and institutions being evolved over a period of time. I would like to refer to Nirvikar Singh and T.N. Srinivasan, who beautifully brought this relationship between globalization, right? And they have attempted to explain the important dimensions of the foreign direct investments, right? Foreign direct investments. and have also analyzed the relevance of appropriate tax reforms within India. According to them, privatization, foreign capital flows, and infrastructure development. And as you cross through Bangalore city now, you will see these projects should have been taken over 30 or 40 years ago. When the land was available and it was open, the transport and communication system could have been developed, but still we delayed it to such an extent. Today we find it very difficult for the acquisition of the land for a good project. Then the protest, the matter goes up to the Supreme Court, and by the time the Supreme Court decides and the project moves forward, the project cost would have tripled or quadrupled. So these are all the issues which we need to keep in mind. So privatization, foreign capital flows, and infrastructure development all intersect in the realm of foreign direct investment. An important part of Indian economic reform agenda has been to attract greater level of foreign direct investments. And I think the young students should understand that our Deputy Chief Minister went to Davos recently in January 2026 and invited many investors to come to Karnataka so that they can provide all the infrastructural facilities that is required. And I think Karnataka also got a good level of investment in the state. So therefore, you have a recognition of the states to play a meaningful role at the international level today, as we have already mentioned, previously a few minutes ago. And therefore, there is a competition among the states that is created. Every state is going to Davos and saying, no, please come to my state. I will provide all the opportunities, right? And therefore, that competition will also continue to exist. There is also other observation. I will not get into the details of these aspects. Let me just come to the sovereign power of the states in taxing. And I think the Constitution of India, which is also based on the Government of India Act 1935, where we have drawn lots of lessons from that. And ultimately, the GST regime had to come into picture, and a destination-based value-added tax was already in existence in a large majority of the states. And therefore, after the 13th Finance Commission, which strongly recommended for the introduction of GST, the Goods and Services Tax, the first official announcement was made by the then Finance Minister, Mr. P. Chidambaram, in 2007, while presenting the Union Budget. He had announced that GST will be introduced in India with effect from 1st April 2010, but that did not happen. It took 6 years more than what it is indicated by the then Finance Minister, right? And it is based on the empowered committee's recommendations. It is not that the central government wanted to impose some tax and imposed it directly. It's a proper consultation taking place between the union and the states for quite some time. And ultimately, this Constitution 101st Amendment Act was passed in 2016, right? Now, what did this act do? I would like to just quickly make a mention about the amendment. This Amendment Act of 2016 inserted 3 major provisions. I think Justice very clearly made a mention, Justice Thurai Raja made a mention about those 3 articles, 246A, 269A, and 279A. The students should take this opportunity to see the content of Article 246A. It is for the first time in the Indian Constitution, it provided an opportunity for concurrent power of taxation. Earlier, there was no concurrent power. They were all very clearly divided between what the union can tax and what the states can do. But for the first time in 2016, that the concurrent power of taxation was given both to the center and the states through Article 246A, which is a unique provision in the Indian Constitution today. I will not speak about 269A a lot because that gets into technicalities. I would also understand and appreciate the students to look at Article 279A for two important features. The first feature is the creation of GST Council. And in the composition and in the voting pattern, which Article 279A provides, it is very, very beautifully articulated, right? Because the center will have 33% of votes. All the states put together will have 66% of the votes. But to take a decision, they require 3/4 of the votes. Neither the union can dominate or dictate terms, nor all the states can join together and blackmail the center. It's a beautiful balancing, unless and otherwise you read the language in Article 279A, you will not appreciate it. Otherwise, you will fall prey to the politicians. They are saying, no, our voice is not heard. It is not individual voice being heard. It is a collective wisdom of the states, that is 66% of the votes, and the wisdom of the center, that is 33%. They have to come together and they have to secure 3/4 of the votes. What a beautiful way of putting it. By and large, there must be unanimity, that is the best one. If not, at least 3/4 of the votes will go in favor of that decision-making process is something very, very interesting to watch, very, very interesting to read. Please go back and read your Constitution, particularly Article 279A. I will tell you why you should read it at the end of my presentation. The second thing is the GST regime also respects certain states which are not manufacturing states. And therefore, they have identified 11 states in Article 279A, and they have provided some special provision in favor of these 11 states. So it is not that the center is dictating terms on all the states equally, that you have to behave. We don't bother about you are a big state or a small state, whether you're a producing state or non-manufacturing state. They are not bothered about it. But they have considered very positively the states which are not manufacturing states and provided special provisions with reference to 11 states. I think these two important features are essential for us to understand the meaning and the depth of fiscal federalism in this country. Having said that, the fiscal federalism itself refers to the financial relations between the union and the states. And I think elaborately we have provisions, including the Finance Commission, which is giving recommendations for the distribution of revenue between the union and the states. I will not get into the details of that. Now, apart from amending and bringing these three articles, the Constitution 101st Amendment Act 2016 also did something more than that. It amended 10 other articles. It made minor changes in 10 other articles, Articles 248, 249, 250, 268, 269, 270, 271, 286, 366, and 368. So it has been very well considered and articulated. Wherever the impact is felt, the Constitution is able to respond to that. I think that is the beauty of this particular amendment. Apart from that, it omitted one article, Article 268A, made one amendment to the 6th schedule to the Constitution, and made 7 amendments to the 7th schedule to the Constitution. So it is not simply creating a GST regime by creating the GST Council. No, they have considered every aspect of it, and that is how the detailed amendments are coming to picture, right? So with these provisions, what is expected is, as Dr. Abdul Kalam has mentioned in 2002, a facilitation for the cooperative federalism to emerge. You will fight, no doubt about it. In which family there is no fight? We fight, but we stay together. Right? In educational institutions, we fight amongst ourselves, but we stay together. Therefore, in the GST Council also, the states have to fight because they have to establish their right, their claim. But at the same time, let me also caution the youngsters, please do not fall prey to the political dialogues at times, saying that we are paying more taxes, right? But we are not getting the dividend from the center to the same level. It may not be to the same level. Because if those 11 states are also part of the Indian Union, they have to develop in a manner like what Bangalore has developed. And if that is possible, the whole body develops, the whole union develops. And therefore, no state should say that I am contributing to the pool and therefore I should get the same amount. That is some aspect which the young students should look at, understand, and then do lots of work in this particular area. And let me tell you, if you become a specialist in this particular taxing, GST, I think you will make your life. You don't have to appear before the courts anymore, right? That is the level to which these things are gone. I don't want to read the list of the 11 states which have these special provisions, right? Recently, on 15th August 2025, the Prime Minister unilaterally announced the next generation GST reforms, presenting the Council with a fait accompli, right? It did not pass through the GST Council, but I think he announced as a policy of the government, right? Consequently, in its September 3rd, 2025 meeting, transition to a three-tier structure of three different rates, 5, 18, and 40%, was adopted without much of debates, right? Now, the Supreme Court also, in the Union of India versus Mohit Minerals in 2022, held that the GST Council's recommendation are only advisory in nature. They are not binding, right? Which gives some sort of authority for the center to reject it, modify it. So therefore, the court said that it is only advisory, not binding. And the union and the states both enjoy simultaneous legislative power under Article 246A, and treating the Council's recommendations as binding would undermine fiscal federalism. Right? Very beautifully, the Supreme Court articulated the meaning of fiscal federalism in this sense. Now, let me tell the young audience here, not everything is fine with GSTN because, as I mentioned, it came into being only in 2016. We are exactly going to complete 10 years of its existence. And it is the right opportunity that the KLE thought about fiscal federalism at the end of the decade. There are certain issues. The issue, I think part of it has already been raised by Justice Thurai Raja in his presentation, use of technology, right? Earlier, if you have gone on road to many places, the moment you cross the states, you will have a check post here, a check post on the other side, right? And it was a nightmare for many of us to travel across these borders because the trucks loaded with goods, waiting for days together to get the clearance. All these things, today, everything is done online. It is virtual, right? There are no physical papers. There are no physical tax collectors standing there and collecting the revenue, right? But everything is purely based on technology. But technology does not come freely. The number of servers that they have, right? The number of systems that are being operated all over, the number of preventive measures against cyber threats, day in and every second, the government of India is worried about the cyber threat. Because if it can, I hope you remember, AIMS website was hacked, right? The entire details of all the patients under this, vanished in no time. If that thing can happen to GSTN, then you just imagine. So therefore, they have to be very vigilant. It is adding cost, and the World Bank in its 2020 report found that the Indian firms now spend more time on indirect tax compliance, right? They are spending more time on indirect tax compliance than their counterparts in OECD and other emerging economies. I'm not finding fault with this. The OECD economies started using this system much earlier, so they have stabilized. We started using it only now. It will also stabilize over a period of time. So we don't have to bother much about it, but the OECD marked it, right? A 2021 survey by the Federation of Indian MSMEs reported that compliance time for small firms nearly double in the initial years of GST. Yes, it will be, but slowly it is coming down, right? While cost rose by 30 to 50% due to increased reliance on accountants, software, and intermediaries. Industry bodies such as CII and FICCI, PICI, have also highlighted liquidity uh, stress caused by delays and disputes in input tax credit, especially in thin margin sectors. I think these are all small skirmishes that may take place, but over a period of time, everything will be all right. That's my expectation. By way of few concluding observations, I would like to mention that GST remains, and it will continue to remain for some more time, as one of the most ambitious fiscal reforms undertaken in independent India. It has dismantled internal tariff barriers, rationalized a chaotic rate structure, and largely eliminated the regressive cascading of taxes through the input tax credit mechanism. It also avoided corruption to a great level in the collection of this revenue, right? Nearly now 10 years, GST still remains as a work in progress. It is not complete. It is still a work in progress. And the unfinished agenda is substantial, right? And I think the fight between the union and the states, not all the states, some of the states, based on party politics, these are all artificial tussles, which I think will vanish in the years to come. And probably we'll have some sort of compromise between these two, and things will emerge better in the years to come. The second issue that I would like to mention is, you must have seen in the newspapers that this month the GST collection has gone to 1.5 lakh crores. 2 months later, 1.7 lakh crores. I think recently they also said 2 lakh crores. But these are all numbers, and I'm not an economist. I'm not a tax expert. But please don't go with the number that is indicated. It is the collection, because part of that has to be returned back. That they are not mentioning. How much of this 2 lakhs will go back to these traders, we don't know, right? So therefore, we should also look at the difference between what is the actual revenue coming into picture. During before coming here, we had a small discussion, and we were discussing that the state's ability to collect was around 20 to 23% earlier. Now it has come to 41%. The tax has increased for the states concerned, and therefore this is one side of looking at it. But the amount of money spent on the collection administration, enormous amount of money has also been saved by the states. That we have to calculate to see the benefit of it. So the definite object of fiscal federalism, right, is to accomplish equal economic development for all the constituent units. And therefore, I am strongly in favor of the special provisions accorded to the 11 states under Article 279A, right? I have not visited all these states, but still, I'm strongly in favor of that. The journey through the evolution of federalism shows how federalism in India is strengthened within a centralized constitutional framework. Right? I will not get into it. This 101st Amendment Act, right, has revolutionized this important feature of Indian Constitution by granting concurrent powers to the center and the states in the matters of taxation. Right? Before I resume my state, I would like to mention I had a discussion with the NASIN, which is responsible, for the indirect taxes training centers. I was told that they require a huge number of tax consultants for GST compliance, a large number. So if you think that you have to go to the courts to appear before the courts, carry the files for your senior, please forget that for the time being. I would request your Dean, Professor Mallikarjun, to interact with the NASIN administration or the finance department of the government of India and offer, in association with NASIN, the training center is not very far off from here, to bring individuals who could train the students, maybe in a certificate course or a diploma course, right? That will take you to a greater heights than your normal appearances in the course, which may take a longer time to stabilize and help your family. And possibly I will try to discuss with Professor Mallikarjuna later and try to get you these diploma courses so that a meaningful understanding and appreciation of fiscal federalism can be done by the youngsters, the Gen Z, who are the future of the 21st century. I thank Dr. Mallikarjunaya for giving me this opportunity to come and share a few thoughts of mine on this occasion. Thank you very much.
Thank you, sir, for your valuable words. Now I invite Professor Dr. J.M. Mallikarjunaya, Principal, Kelly Law College, for the presidential remarks. Sir, please.
Honorable Mr. Justice Dore Raja, former Judge, Supreme Court of Sri Lanka, our beloved teacher, Professor Dr. V. Vijay Kumar, esteemed resource persons for the plenary sessions, Mr. Kodandram, Mr. Tarkesh, Mr. Atmaram, my dear colleagues, and the student friends. There are honeybees, there are infectious insects. Learning from His Lordship, Dore Raja, I would like to share my thoughts. While the honeybee doesn't crush the flower, rather helps blossoming of the flower by giving pollination effect. Infectious insects crush the flower. What am I trying to bring home with this metaphor? The point is this: has the state remained the honeybee, has become the infectious insect. There is hardly any justification for the state to put its hand on my pocket with the hard-earned money. However, there is an agreement that we all have agreed to sponsor the state expenditure through the tax. Thus, the taxation system gets justified. If it is to be justified, coming back, is the state playing the role of the honeybee or that of an infectious insect? Through the deliberations that we had over almost a decade before 2017, our wisdom almost concluded that the state is not playing the role of honeybee, but playing the role of infectious insect by providing double federalism or double taxation, etc. Imagine if a truckload of goods have to move, a truck has to move from Bangalore to Delhi. It was almost like crossing the international borders so many times. There were such issues related with the system that we had. So the wisdom went in favor of embracing, adopting GST, which sounded to be a very lovable honeybee in taxing the citizen. That's how the CST has come into place. So I'm sorry, GST has come into place. I'm sure lawyers do not appreciate conclusions, they appreciate dimensions, and they have to be so. At least it is one of the dimensions through which we could look at GST framework. While we look at GST framework from the angle of tax, there is another angle, very important angle, which we have gathered here to deliberate for 2 days. GST not only improvised the indirect taxation system, it gave a great tool for what we otherwise call as transformational constitution. The federalism, a basic structure of the constitution, undergone a transformation through the tool of GST is what, as lawyers, we should look at. What are the how GST stood as a tool for transforming constitution? Whether GST balanced the competitive connotations or the ideas of competitive federalism or cooperative federalism. There are a lot of dimensions to say that it is a cooperative federalism. I subscribe with Professor V. Vijay Kumar when he describes it as the robust cooperative federalism. Of course, there are flip sides of it. And in this conference for 2 days from now, you will be deliberating about having understood that GST is a work in progress. It has to be, if it has to be cherished as the cooperative federalism, we should look at, we should work on, and we should see what is the direction in which this work should progress. Almost a decade of working of GST. It's a work in progress, we call a living organism. It is rightly said so, being a fundamental aspect of constitution. So during these 2 days, we would rather be deliberating on in which direction this work should progress. It is a nation of diversity. It is a nation of haves and have-nots. GST is expected to be haves providing the have-nots, one of the ideas of GST. So there are a lot of underpinning issues with GST. I appeal to all of you through 5 plenary sessions after this inaugural session and through the technical sessions. These issues that are deliberated here are going to be delineated and discussed in detail, giving you an idea as to in which direction the work of GST should progress. So please do participate in the coming plenary sessions and the technical sessions and have the best from this very humble exercise from our side. I think with these appeals on this occasion, we are already running late by 30 minutes. We'll quickly have 5 minutes of break and resume for the technical sessions. Wish you once again a very happy learning for these 2 days. Thank you.
Thank you, sir, for your guiding words. I request Dr. Madhusudan Ji, Associate Professor of Political Science, to deliver the vote of thanks.
As said by Mahatma Gandhi, the tax on each man's food is a tax on his life. A government that is based on justice should always keep this in mind while framing its fiscal policies. Good morning to one and all present here. It is a profound honor and privilege to stand before this distinguished gathering to propose the vote of thanks for the inaugural session of our two-day international conference. First and foremost, we extend our heartfelt gratitude to our chief guest, Honorable Mr. Justice S. Thorairaj Sir, former Judge, Supreme Court of Sri Lanka. Your presence has lent immense international significance to this forum. Your insights into the global legal landscape and taxation frameworks have set a perfect tone for the technical sessions to follow. Thank you, sir. Request Principal, sir, to present a memento as a token of gratitude. Please, sir. Yes, sir. We are deeply grateful to our guest of honor for delivering keynote address, Dr. P. Vijay Kumar, sir, former Vice Chancellor, National Law Institute University, Bhopal. Your enduring commitment to legal scholarship and your presence here today is an inspiring to both faculty and students alike. Thank you, sir. Request Honorable Mr. Justice Thorairaj, sir, to present a memento to his guru as a token of gratitude. Thank you, sir. A special thanks to the president of this function, Professor Dr. J. M. Mallikarjunaya, Dean, Faculty of Law, KLE Technological University, and Principal, KLE Law College. Sir, your visionary leadership and unwavering support are the driving forces behind such high caliber academic initiatives. Thank you, sir. I also acknowledge the tireless efforts of Dr. Manoj Kumar, Dr. Mahesh, Dr. Vishnu Prasad, organizing committee, the technical staff, and our student volunteers who have worked behind the scenes to ensure the seamless execution of this inauguration. Finally, I thank all the delegates, researchers, and students. Your active participation is what breathes life into discussions. We look forward to participate in the 2 days of this rigorous academic engagement. Thank you all. Thank you once again. Jai Hind. Thank you, sir.
Thank you, sir. This brings us to the formal conclusion of the inauguration ceremony. We are looking forward to have thought-provoking and insightful discussion. I request all the dignitaries and participants to kindly proceed to the high tea, followed by the plenary sessions in the 4th floor AV room. Thank you all for your gracious presence and participation. Thank you.